Hi everyone, today's story is about this Chinese national who wanted to come to the United States and get a green card. They are not in the United States. This Chinese national is actually in the auto industry. I can't say exactly what, but he wants a green card for his stellar work that he's done in China. He's not in the United States and he's filing for the national interest waiver. And here I have the most brutal national interest waiver request for evidence from USCIS, in which I'm going to read some of the languages so at least you can see that USCIS is not just targeting you, they're targeting a lot of people. And this was, again, one of the hardest cases that we had to work on, but we were able to help overcome it. So I'm glad to share that with you. Let's go. Okay. Hi everyone, my name is Joseph. I'm the managing partner here at Tsang and Associates, where we solve legal problems with creative solutions. And so the legal problem in this case is this Chinese auto worker who, in the tech industry of automobiles, wanting to get a national interest waiver, skip the entire line and come to the United States and get a green card. Again, most people who are filing for NIWs, they're already here on H-1B, they're already working, they're already making significant strides and contributions. But this guy, still in China, wants to come here. And, you know, given the US-China dynamics, it's very, very strict scrutiny. And again, US automobile invented it. We are the best. Arguably, what can this person do? That is the prejudice and hubris that we saw throughout this challenging request for evidence. And let me read through them one by one. The way I'm going to structure it is I'm going to read through the challenge, and then I'm going to go through how we answered and what we provided, so you can kind of compare, and then we're going to go through all three, okay? So the first prong, substantial merit and national importance. USCIS writes, the evidence concerning the petitioner's undertaking does not establish that his proposed endeavor stands to sufficiently extend beyond his employer to impact the industry more broadly at a level commensurate with national importance. The petitioner has not sufficiently demonstrated that the particular work he proposes to undertake offers original innovations that contribute to advancements in the industry or otherwise has broad implications for that particular field. And then it goes on and on. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 paragraphs, all of them starting with the petitioner has not demonstrated. The petitioner submitted this, but is insufficient. It submitted this, but is insufficient. As previously discussed, it has to be national importance. And then it gives a list of things in which they want. Evidence to establish that the beneficiary's proposed endeavor has national importance consists of, but is not limited to, the following: detailed description, documenting evidence, etc. I loved our first line in responding to this. Check this out. Check out this IRAC, right? The service, this is us saying to the service, right? The service requests additional information regarding the national importance of our client's endeavor, specifically whether the proposed endeavor extends beyond the employer, and then etc. Number two, the particular work he proposes to undertake offers original innovations that contribute to advancements of the industry and has broad implications. And then we start. Our client responds with yes to both questions. And then we go on 1, 2, 3, 4, 5 pages in proving that. And then we didn't argue specific law. We just directly went to bullet point. 1, 2, 3, 4, 5, 6, 7, 8. 8 bullet points talking about how this is national in both scope and importance and extends beyond the different industries. And then we have a lot of different letter recommendations from different people and on all other industries using the systems that he helped implement, right? So intelligent operation management, autonomous safeties, personal assistance, AI, all of this would benefit from his involvement because that's what he worked on. So other industries can use it as well. So we jumped very specifically into what he's doing. We didn't argue abstractly like auto industry is important. China is a competitor. China is doing really well, and therefore U.S. needs to learn. We didn't do any of those broad ideas. We went super specific into AI, into autonomous driving, into this the thing that he worked on, and this has broad implications not just to the U.S. employer and the U.S. employers. Like so many automobile industries are all trying to tackle this particular problem, but he is doing it, has done it, is going to do it, and therefore is worthwhile. So that's how we overcame that. Now the second prong, that he's well positioned to advance the proposed endeavor. Again, the service rights. The evidence submitted does not support the statements that the petitioner will be able to significantly make contribution at this time, nor does it appear that the petitioner is currently well positioned. And then it goes on 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 paragraphs saying why our client is not good enough, and then lists out a full page, 2 pages actually, of all the things that they can provide to show that they are well positioned. So let's look at what we did. Again, we used bullet points. Our client respectfully submits additional evidence showing that he has advanced education and the experience, which he has applied already to achieve successful advancements in this proposed endeavor, and he exceeded the standards of merely providing plans. He is already obtaining professional network and interest from industry leaders, brands for partnership, collaboration, and licensing. So we showed that he has the education, he has the work experience in which he already did significant contributions to the field using EB-1A arguments, by the way. And then he goes beyond that, showing all the things that he was able to do. This last part is the last tangential thing that we kind of threw in, is not part of the case law, but it's always good, right? Because again, these EB-2 priority dates are like 5 years. So we want to show that he is going above and beyond, right? We always go above and beyond what USCIS is requiring. And then we went through all his letters of rec. Now, he submitted, I think, 5 really powerful letter recs from PhD professors, from industry leaders, from employers, showing his significant contribution. So these are like top dogs in the field writing letters for this individual. Again, letters alone, USCIS don't accept it, but he has so many other things to substantiate his involvement. So that was how we overcame the second prong. Then the third prong, on balance, is it beneficial to the United States to waive the requirement? And again, USCIS writes, the petitioner has yet to establish his endeavor has national importance, that he is well positioned to advance his endeavor, or that there is national interest in his participation. He goes on and on talking about how the client is not good enough. And then they end with this: withdraw, all cap, underline. If you wish to withdraw the petition, please submit your request in writing. The fee is paid for the filing of the petition and cannot be refunded. That is a WTF line, like, why would you include that? That's something that I always talk to USCIS about. Like, why would you even include that? If you are saying you can withdraw and we will refund you, then I get it. Right? Oh, that's so nice of you. Thank you, right? We will refund you halfway. But if you're saying you won't refund and you put that in there, that's like, what is the client supposed to do with that? Right? I mean, what's the point? It just makes people feel bad. It's not a good thing to read, because you work so hard, you build out all these things, you ask so many favors for people to write you letter recs, and then you build 500 pages of documents, you submit it, and then you see this line, if you wish to withdraw, you can. Why would you do that? And some clients have even said, does that mean USCIS wants me to withdraw because they put it there? And I always have to explain, no, it's just template. Then they ask, well, why would they put it in there? Everything that the US government does is well thought through. And I would say, yeah, maybe not. Think again. I'm not talking about politics here, but it definitely is not well thought through. It's just a template. And they're like, but it's there. So we always have to go through that discussion. So if you see this on your request for evidence, it's not you, it's them, okay? So how do we overcome this third prong? We wrote 1, 2, 3, 4 pages detailing how his involvement will benefit the United States and in all the different industries as well. in manufacturing, in healthcare, in infrastructure, in public safety, in industrial operations. We showed that this industry, AI plus automobile, is so important to the national interest. He's already done so many things. He's well positioned to do it well. It has broad implications in all these different fields. And that's why by waiving this requirement, allowing them the green card will not substantially harm this entire process. The labor cert process and the EB-2 process. I don't know exactly which part the USCIS officer reviewed and felt okay with, but it was a 19-page attorney brief. We had over 37 exhibits, 5 letters of rec within this 37, but majority of them, 20 plus, were just in-depth research that our team and the client did over the course of like a year, searching for industry reports, talking about the industry, talking about other industries that's not even directly related to the automobile industry. It was definitely the hardest NIW case I think that we've done, arguably. It was borderline, right? There were so many parts that was hard. The client didn't have a super clear idea of what they're going to do. They just know that it's really important to do. And also, it's one of those things is like if you apply, it gets approved, you're going to come into the United States 5 years later to get a green card. So they couldn't do too many things. So there were so many things that was difficult. But based on the law, based on the requirements, based on the supporting letters, we were able to prepare it, file it, and get it approved. So if you feel like your case is hard, if your case got denied, definitely don't lose heart. You could definitely try again. These things are always changing. Look deeper, look broader. The world is constantly changing. The United States is changing with different policies. Find policies that are in your favor and make the best argument you can. If you have any questions or comments about this case, feel free to reach out. Take care. Bye-bye.